So we're not necessarily arguing to say that every R1 donation that is critical or incredibly important. The Constitutional Court itself was at pains to say that it is indeed possible that some contributions might be trivial, or that some very low thresholds or some contributions in kind to supporting a political activity might be justifiable. But the important thing is that justification, the onus would be on Parliament to establish, because it is about justifying a limitation of the rights of people to have an equal vote and an equal say in democracy, and the limitation of people's right of access to information, which is the starting point. We, as My Vote Counts, who didn't propose a threshold ourselves, R1 seems unlikely. But I mean, importantly, when you're talking about compliance requirements for the IEC and SARS, the R1 is recorded in any case. It is reported to the IEC. But the question is simply whether or not we, as the public, should have the right to know about who is contributing to one extent. So when you're talking about
why should the public know anything below 100,000? Do you feel, especially when it comes to, you say, ignoring cumulative donations from related entities?
Well, we're saying ignoring cumulative donations, we say, is one of the major weaknesses with the Act, because it basically gives like token acknowledgement of the fact that the right of access to information and transparency is important. But if you can donate up to 99,000 Rand, that's not an insignificant amount of money. And that's something that we say that Parliament has not come close to justifying as something that you should be able to do in secret, and especially if you're able to do so with repeated different related parties. That's something that we read is not prescribed by the Act at all. That's part of why we say that it's irrational. It acknowledges that the public having knowledge about who controls and who funds politics is something which is significant, and something that is a right that's established by the Constitution and has been confirmed by the court. But then the mechanism itself doesn't meaningfully guarantee that sort of access. We say the R100, and especially with the multiple loopholes, 100,000 Rand is just utterly inadequate and has not been justified as a limitation of the rights of the South Africa's democratic population.
So if the court was to set the threshold at 100 Rand, would that be enough? Would that change anything?
Well, so the court wouldn't set the threshold. That's incredibly unlikely, and we're not asking for that. That's why we, as the court, haven't gone and said that we want a threshold of 100 Rand. It's not for us to say what is or would not be trivial. But the whole point is that nobody, and I think the political parties themselves, are not justifying this threshold on the grounds that anything below 99,000 is trivial. When you look at the budgets that were actually declared and the amounts that they're operating with, you realize that a person in South Africa who can spare up to 100,000 Rand for political activities in a discretionary nature is an elite, and is doing so to attempt to influence politics. And so it's up to the political parties and the donors to justify why they are their entitlement to operate in secret and to use political, like private capital in this way to control politics is something which is justified. I think 100 Rand personally would be fine, but that's not the case that My Vote Counts brings to court. We are simply to say that the current regulation is inadequate to protect the rights everyone acknowledges are important.
Werner? Apparently you guys are operating in secret here by accepting donations that are less than 100,000. What do you make of this entire situation? Should it be a lower threshold? Ultimately, My Vote Count says you guys are the ones that get to choose.
Good evening. My apologies. My connection seemed to be a bit unstable. Was that directed at me?
No problem, Werner. But what is your thoughts with regards to this entire situation? Are you in agreement that perhaps there shouldn't be a threshold at 100,000? Should it be lower? Should there be no figure at all?
Look, firstly, I think what is important to remember is that the Constitutional Court already made it very clear that, and I think that part has been admitted this evening, that around thresholds, there's a policy choice available to Parliament. So in as far as Parliament has to justify it, I think there's, of course, other rights in play, and not only the right to information, but also the right to privacy of those who donate to political parties, which has to be balanced ultimately with the right to information. The way we see the right to information unfolding, specifically where it's information not held by the state, is that there's a reasonableness requirement and ultimately a requirement that the information should be useful to whoever is looking for the information. And in that sense, the Constitutional Court also, when it previously dealt with an application of My Vote Counts, said that it is the type of information essential to complete the picture of who a political party is and who influences. So whilst there's no denying that there could be undue influence through donations in South Africa, the flip side of that coin is, of course, also that in a country where for very long one party had a stranglehold on political power on a national level, the mere fact that they would be identified scared off potential donors of other political parties. And that also, in our view, has to be taken into account.
Sure.
Okay. So whilst it's interesting to note that My Vote Counts now say that it's not all donations that they seek to be declared, I would want to say that is, as a matter of fact, the case they make out on their court papers. So whether they've since realized that it's both impractical and unfair to private smaller donors, members of parties who have a right to privacy,
sure,
have a right to also a secret vote to an extent, it would be an interesting question to ask with them.
Yeah. Elisha, I'm going to let you respond in just a moment, please, if you'll allow me. I just want to ask Michael Beaumont, your thoughts with regards to just what you've heard so far, particularly then from My Vote Counts then, and whether you agree then with the Democratic Alliance's Werner Horn.
Well, I think it's very odd, firstly, that My Vote Counts comes to an interview this evening and says that donations of 99,000 are would-be corruptors that are out to buy influence in the political system. Their own website involves a number of donors, including international donors, making multi-million rand donations. And their website has the following quote: "My Vote funds comes from diverse range of sources. Our donors have no material influence on our work." So it's interesting that they have a different standard and are able to deem themselves free of influence, but suggest every other donor is contrary to that principle. But I think what My Vote Counts is fundamentally misrepresented is that the Constitutional Court judgment that gave effect to the idea of the Party Funding Act spoke about the idea of reasonable access to information. It wasn't an unqualified right. And the question we have to ask ourselves is it reasonable to believe that a donation from a lady in Soweto for 20 rand and a gentleman in Bloemfontein for 30 rand really can buy influence in a political party, and these individuals are conspiring in order to do so? And is it reasonable to invade the privacy of those individuals in such a manner that effectively we are conveying publicly who they vote for, when in real terms, if people make donations of that kind, they invariably are going to support that political party? And then, of course, is it reasonable to expect that political parties in the IEC should have to spend millions of rands administratively to be able to produce reports of multiple data points on all of these donors?
Yeah.
And is it reasonable to believe that the South African people are in desperate need of the information as to who donates 10 rand to each political party? And I think when you ask yourself these questions, you'll realize that it's not reasonable, and My Vote Counts is being inherently unreasonable here, because where it effectively falls flat on this argument is the idea of the freedom of speech. It's not just about the freedom to impart ideas, it's about the freedom to receive them.
All right.
And if you're going to make private funding as difficult as My Vote Counts is openly trying to do, really what you're going to do is limit the ability of political parties to campaign and go out there and offer their alternatives to more places and communities across our country, effectively creating a status quo. And that's a real problem in a country rejecting the status quo.
Elisha, your response? I'm not sure. I think you're muted. Sorry. Yeah, Elisha.
Yes, sorry. I was muted. A few things. I think one, the fact that Mr. Beaumont mentions that you can look on My Vote Counts' website and you can see who the funders are. I think that is significant. That is important, even though it's not required by any law, because we are not a political party. We think that transparency is actually helpful if anybody wants to make accusations about corrupt influences or what the relationships are. We're not arguing about whether political activity should be possible. This is a question about how much political activity you should be able to control in South Africa's politics secretly, and whether and not necessarily assuming that all of that is corrupt. And I think everyone agrees, and the Constitutional Court certainly held, that if you're going to be able to have a significant influence on the policy platform and the direction and the activities of South African electoral politics, then the electorate has the right to understand that influence. And we say that the threshold and the multiple loopholes in the current law doesn't achieve that goal that we all acknowledge as being important to analyze. Also, I just want to clarify that I'm not saying that we are happy to have some threshold. That's not my job. That's not a position that we have to take. What I was saying is that what the Constitution holds and what the law requires is that if you are influencing politics and you are funding public politics in the electoral realm, then the public has a right to know. That's a constitutional right, which is linked to the right of access to information and to the right to vote. It's that fundamental. And any variation of that, or like departure from that, even if it's 100 Rand, is a limitation of the right, and justifying that is something that they would have to do. And the court said that perhaps 100 Rand would be fine, and then they would have to show that. What we're saying is that the laws that were put in place by Parliament, which is 100,000 Rand, and then you can just come back in wearing a different outfit the next day and give another 99,000, and the various loopholes just do not achieve the rational purpose that's acknowledged. That wasn't me conceding necessarily that thresholds are important.
Okay, look, Elisha, we're going to continue this conversation. We just have to go to a short break right now. But I want to talk about elements that you speak about, which are, one, significant influence. Who should determine that ultimately? Two, the right to information versus the protection of one's information. And then two, usefulness and essentialness. Just if we can unpack those just a little bit further, I think will be very important as well to get into. My Vote Counts back in court in a bid to have Political Funding Act declared unconstitutional. That's what we're unpacking. Back with you on that debate right after this. Welcome back. Thank you so much for joining us here on Newsfeed PM, the late edition. My name is Arabile Kumete. Now, we've been just continuing to speak about the situation around My Vote Counts being back in court then today in a bid to have the Political Funding Act declared unconstitutional, wanting political parties as well as independents ultimately to be forced to disclose all private donations, regardless of the amount. Just before we went to the break then, I asked Elisha Kunene, who is the lead then for participatory democracy at My Vote Counts, just around significant influence. Who ultimately should determine that? And it's important because that's what determines the threshold ultimately, whether it should be at 100,000 Rand, whether it should be less, whether somebody's going to have significant influence over a political party. Who determines that? Elisha, your thoughts?
So we think it should be Parliament, right? And in a process
But
which
Parliament is made up of
obviously.
these political parties, right? Just sorry.
Yes, yes, but in a process which, in a proper legislative process, which researches, considers all of the factors that are brought before it, and actually weighs the interest and concerns that are raised. Ultimately, it is something which can only be exercised democratically. It would be undemocratic for us as an NGO to try to like declare from on high that this is a correct threshold. And even saying zero is not necessarily something that we're, preaching as a gospel. We're saying that that is the starting position of that, what access to information requires, because it's information which exists. The IEC has to receive this information. It has to be collected anyway, just as SARS would expect all the relevant information which relates to what your tax return. The question is whether we as the public are a concerned enough actor to actually know what those numbers are, or whether we should only know whether it's something about in the few millions, so we only see the handful of billionaires who feel like publicizing their donations at present. Ultimately, the policy decision is one which can only occur democratically, but Parliament would need to go through a much more rigorous process that weighs the rights properly and doesn't just pay lip service to the rights which we acknowledge.
Michael Beaumont, you ultimately serve the people, right? How do you define significant influence? How do you define when one person has significant influence over a political party? And should that be the determining factor to this threshold? And your thoughts?
Well, again, I think it's important to say that there has been consideration around these numbers. These numbers don't come from nowhere. And you've got to understand that the work of running a political party that is able to campaign across the 9 provinces, 278 municipalities, and 4,400 odd wards is an extraordinarily expensive exercise. It's not a cheap thing to offer a political alternative in our country, especially one across all 9 provinces. And in real terms, while 100,000 Rand is certainly a lot to many South Africans, myself included as an individual, I can assure you the amount of money involved in running a political party is astronomical. Parties spend tens or hundreds of millions of rands at election campaigns, and the notion that 100,000 Rand is enough to simply buy influence in an organization, it's childish in real terms. I think we must also understand that when the figure was produced, it was about a balance. It wasn't just simply about saying, what's below there must be concealed. It was about balancing the rights of South Africans to privacy when an amount is small enough that it doesn't warrant an intrusion on their personal privacy, or doesn't warrant the administrative burden of hundreds of thousands of rands, hundreds of thousands of donations having to go through an intensive data collection and reporting phase, both with the IEC, which is a publicly funded organization, or the private institutions of political parties. I think at the end of the day as well, what is concerning that we find about the litigation of My Vote Counts is their attitude towards private funding is hostile. They believe that the state should simply fund political parties, and it's quite a Marie Antoinette type approach to say that the overburdened taxpayers of South Africa should fork out more than the 1.5 billion Rand per annum they're already forking out to political parties represented in Parliament. And at the end of the day, we have to put forward the view that it is the work of political parties to go out and convey their alternatives to communities who are looking for a political alternative in South Africa. And I think the big concern from our point of view, Arabile, is that we could look at the situation in South Africa with new political parties that are not yet represented in Parliament. They don't receive any state funding. And if we're going to have a situation where an entity like My Vote Counts comes in with the agenda to prevent private funding, what you're really going to do is create a situation where the established players have a stranglehold over politics in our country, and the barriers to entry for new political parties are so high that they aren't able to provide that alternative across the length and breadth of our country. And that is a serious concern. That is why these thresholds had to be considered at a reasonable amount. And I think at the end of the day, that figure has been produced with those balances in mind.
Werner, you agree 100,000 ultimately a reasonable amount?
Well, it depends on the context, but let me just maybe firstly say one of the arguments we've of course put in front of the court is that to an extent the current application and court action by my vote counts as premature in the sense that Parliament, of course, on the back of the amended Political Party Funding Act, is, as a matter of fact, at the moment busy with that very exercise Elisha is describing. Busy with public participation to ultimately settle on a resolution. And in terms of the amended act, the president is then to set new thresholds and limitations based on that specific resolution of the National Assembly. But to get to your question around 100,000, definitely in the context of what it costs to operate a political party, and as Michael says, what it now costs to campaign, 100,000 rand, as big an amount as it is but a drop in the ocean. You know, we've, in terms of the founding affidavits of the Democratic Alliance, have advised the court that private funding now accounts for about 20% only of our income. We, of course, benefit from the allocations to represented political parties. And ultimately, in an election year, that 20%, of course, might slightly increase. But to argue that any one of those donors ultimately will have a stranglehold on what the party promises or ultimately does if it enters into government is a bit of a fictional exercise. It is also interesting that, of course, the one thing My Vote Counts seemingly is not very interested in is the disjuncture at this point around what some political parties do disclose and what they're able to spend, which should be more of a concern to everybody who's interested in the health of our democracy. And at the moment, the legislative framework, which I want to say on the one hand allows, but on the other hand, to give them the benefit of the doubt, enables the IEC to only embark on an investigation of a possible a lack of full disclosure. That specific legislative framework is really a part of the problem. And if one looks towards the health of our democracy and to strengthen democracy, we strongly believe that should also be, or rather be, part of the focus of entities who looks at funding and the influence of funding on political parties.
Werner, where do we draw the line, though, between the right to information and the protection of one's information as well? Then where exactly do you think we should be able to draw the line? Is there a discernible line in this case as well?
Well, yes. Firstly, I think what is good to hear this evening is that there is an understanding, or at least an admission from My Vote Counts, that not all private funding, as it is intimated by their founding affidavits, is a threat to democracy. Smaller amounts, definitely not. Ultimately, we must trust that Parliament, in its exercise of now inviting public submissions and, of course, also expert submissions, will carefully look at what then is the amount which can be justified as the threshold for disclosures to be made, because none of us are arguing away the possibility of political parties being corrupted. But once again, I think, as Michael has also said, this is a balancing act. We must also protect the rights South Africans hold to give expression to their political beliefs, their political persuasion, as the Protection of Personal Information Act calls it. And it's a careful balancing act, ultimately, to decide what is the type of threshold where our democracy could possibly be threatened if that type of donation is not made public.
You agree there, Michael? Just very quickly.
Yes, I certainly do. And I think the part that I really want to get into here, Abila, is this question of the focus of the fight for transparency. When My Vote Counts launched this litigation back in 2023, we reached out to them to say, you know, what you're intending to do is well-intentioned, but the effect is going to be very bad. We need to engage with you, and we need to discuss where the real fight for transparency is, because My Vote Counts thinks that we're going to legislate away the problems of non-compliance with the Party Funding Act, which is just simply not true. We have a number of instances where we ourselves have laid complaints against major political parties in South Africa who are flagrantly ignoring the Party Funding Act, to the point that some of the most well-financed campaigns in 2024 declared only 300,000 Rand, which is just, it's a joke. And, you know, lowering that threshold or removing that threshold is not going to change the fact that there's a culture of impunity with political parties ignoring these provisions of the Party Funding Act. And the real challenge is that legislators have simply dumped the investigative function at the door of the IEC, which has no institutional culture in investigating these matters. And there's got to be real teeth behind looking into issues of non-compliance, which are abundant, I'm afraid.
I actually realized that I've been actually putting your name incorrectly, so I apologize all show. Elisha Kunene, not Elijah, right? I think that's actually what I should have been saying. Elisha, do you agree? Ultimately the sentiment being put forward by both men, it feels as though there's a certain sense of understanding from both parties as well, or from all possibly.
Yes, so I think what is absolutely crucial to recognize is that we applaud the fact that these parties are here as a part of this conversation, as a part of participating in court, and in terms of before the IEC, actually participating in the democratic process, that they make disclosures, that they respect that you should have a law, and one which is developed democratically, and that if there are rights to be balanced, that should be done appropriately, and actually coming to the table in good faith. On that score, that's something that absolutely should be applauded, and any attempts to strengthen the enforcement, the investigation, the regulation, and the capacitation of the IEC for the regime is something that we also support wholeheartedly. Where we might differ is that we might differ on the balancing, because we think that the very fact that you are allowed by the current law to have such vast sums were undisclosed legally is something which makes it even harder to create a full picture of non-compliance, but perhaps that's a little speculative as far as how that affects enforcement on my end. But what I would say is that I think it's significant where we've been in the Western Cape High Court. Mr. Beaumont mentions that 100,000 is not an insignificant amount to him, but that it is childish to think that it could be corrupting. But I saw him in court, and when we were discussing the Cyril Ramaphosa campaign, I think one of our best lawyers, Stephen Budlander, made the point that if I gave the president or a member of parliament a bottle of wine, they would have to disclose that in parliament. You could go on the internet right now and I could see a PDF about the gifts that someone has received, including things as trivial as bottles of wine. And in that instance, it was clear that if I found out that the car that Mr. Beaumont drove to court this week was donated by a certain someone, or somebody is paying for his petrol out of hand the entire year, that might not be the sort of corrupting that means he should be thrown in jail. But whether or not his supporters have the right to know about those sorts of contributions when they are making an assessment about the balancing is something that we view as essential, that the balancing should not just be done by politicians, but by the electorate as a whole.
Yeah, I think I get it. All right. Elisha, appreciate your time this evening. Thank you so much for it, because I think it was key and important to kind of get a clear sense of where you lie, what exactly the basis is, and what political parties understand from all of this as well. So we really appreciate all of you joining us then this evening. Elisha Kunene is lead participatory democracy at My Vote Counts. We also had the DA's Werner who joins us as well this evening. Michael Beaumont, also ActionSA's national chairperson. Thank you to all of you this evening.